major ruling involving the Second Amendment.
The Supreme Court today handed down a major victory for gun control advocates.
As the nation deals with a recent wave of mass shootings, the Supreme Court expanded gun rights.
So the Supreme Court has issued an order in the critical Second Amendment Preservation Act challenge that was pending in front of their court.
Basically, they kicked the ATF in the teeth. They seem kind of punch drunk. They seem as though they got the bell rung pretty bad.
Public safety concerns must be addressed in ways that are lawful. This rule is not.
The Supreme Court just dropped a bombshell that's sending shockwaves through every federal agency in America. An 8-to-1 emergency ruling has fundamentally transformed how states can resist federal gun control, and the implications are already creating chaos inside the ATF. This isn't just another court decision, it's a constitutional earthquake that's about to change everything you thought you knew about how gun laws work in this country. What makes this ruling so explosive isn't just the outcome, it's who voted for it. When Progressive Justice Ketanji Brown Jackson joined conservative justices in this supermajority, legal experts across the country had to pick their jaws up off the floor. Even Justice Elena Kagan, who previously argued for broad state restrictions on concealed carry, completely flipped her position when the question became whether states could refuse federal enforcement. The numbers tell a story that should make every American sit up and pay attention. Previous landmark gun cases barely squeaked by with 5-4 decisions. The Heller case in 2008, 5-4. McDonald versus Chicago in 2010, 5-4. The recent Bruin decision in 2022, 6-3. But this case, 8-1. That kind of supermajority doesn't happen by accident. It signals something much bigger is happening. Only Justice Sotomayor dissented, and her reasoning reveals exactly why federal agencies are panicking. She didn't oppose the principle itself. She opposed what it means for federal power. And that's where things get really interesting. The legal doctrine at the heart of this ruling is called anti-commandeering, and it's the only constitutional principle that both liberal and conservative justices defend with equal passion. Established formally in the 1997 Prince case, this doctrine says the federal government cannot force state officers to enforce federal regulatory programs.
This is a case dealing with a state's Second Amendment Preservation Act, also known as the SAPA law.
The ATF overreach has been stopped once again.
ATF is getting another lawsuit, this time by half of the country.
We want to see Congress pass laws that will help reduce crime without infringing on the rights of law-abiding citizens.
House would keep gun owners' information private.
States said we are going to take away all of the funding that we are giving federal agencies when they come into our state and are trying to violate the rights of residents.
Back then, Justice Scalia used it to strike down parts of the Brady Act that required state police to conduct background checks. But here's where it gets fascinating. Liberal states have been using this same principle for years to resist conservative federal policies. California created sanctuary cities that refused to help ICE with deportations. Colorado and Washington legalized marijuana despite federal prohibition, then banned their state agencies from helping the DEA. Now, with this Supreme Court expansion of anti-commandeering principles, red states have the same constitutional weapon to use against federal gun enforcement. The domino effect has already begun. 27 states representing 157 million Americans have either enacted Second Amendment Preservation Acts, passed legislation through at least one chamber, or issued attorney general opinions supporting state refusal to enforce federal gun laws. Missouri, Montana, Wyoming, Idaho, Arizona, Oklahoma, Kansas, Arkansas, Tennessee, Kentucky, West Virginia, and South Carolina have fully operational laws right now. Texas, Louisiana, Mississippi, Alabama, Georgia, Florida, Indiana, and Ohio have bills moving through their legislatures with this new constitutional backing. The mathematical reality facing the ATF is brutal. They employ 5,000 total personnel, but only 2,500 are special agents authorized to conduct field investigations. Those 2,500 agents must cover all 50 states, 3.8 million square miles, and 335 million people. Meanwhile, state and local police handle approximately 12 million arrests annually. Federal agencies combined, just 150,000. Last year, state and local police made 478,000 arrests for weapons violations. The ATF made 9,200. That's a 52-to-1 ratio. When half the country's states cut off cooperation, the ATF loses that massive force multiplier overnight. Federal firearms enforcement essentially returns to what it was in 1968, before cooperative federal-state enforcement existed. The financial implosion is equally devastating. The ATF's $1.7 billion budget hides a critical weakness. approximately $420 million. Nearly 25% of their funding pays for grants, cooperative agreements, and task force operations that require active state participation. The National Integrated Ballistic Information Network alone receives $42 million annually to maintain databases that depend on state crime labs submitting evidence. Missouri's law includes specific language prohibiting state agencies from accepting any federal grants conditioned on enforcing firearms regulations the state considers unconstitutional.
Pretty based move here by the state of Missouri, saying, no, we are not going to fund federal violations of the Second Amendment.
They really don't know what to do with this one, which is always a good thing to see.
There is a difference between states deciding how they want to regulate any number of things versus stripping people of their rights to self-defense.
Saying setting a higher threshold in an emergency could mean life or death.
This is an issue that every gun owner should be concerned about, and we in Congress should be concerned about it too.
8 other states have adopted identical provisions. When the ATF conducts major operations, they typically sign cost-sharing agreements with state police. In Missouri, before their Preservation Act, the average firearms trafficking investigation cost $43,000, with the state covering $26,000. After, that cost jumped to $71,000 because the ATF must provide everything themselves. If all 27 states enforce these provisions, the ATF faces a minimum $340 million annual shortfall, 20% of their budget vanishing with no replacement funding. But the real crisis goes deeper than money. Every state maintains criminal justice databases containing arrest records, conviction histories, concealed carry permits, mental health commitments, and domestic violence orders. The FBI's background check system depends entirely on states voluntarily sharing these records. Second Amendment Preservation Acts cut off that access for federal gun enforcement. The ATF's National Tracing Center processes 400,000 crime gun trace requests annually. These traces track firearms from manufacturer to first retail purchaser, critical for investigating shootings and trafficking. Missouri's State Highway Patrol maintained records on 280,000 concealed carry holders. Before their Preservation Act, the ATF could request searches to identify potential purchasers of recovered crime guns. In 2024, Missouri denied all 584 ATF requests. The result? The ATF's firearms trace success rate in Missouri dropped from 67% to 41%. If all 27 states implement similar restrictions, the ATF could lose the ability to trace 220,000 crime guns annually, 55% of their total capacity. Without effective tracing, federal investigations essentially go blind. The prosecution pipeline faces total collapse. In 2023, 7,440 federal firearms prosecutions out of 12,000 total, 62%, originated as state arrests that were adopted into federal court. The typical process works like this. State police make a traffic stop, discover a felon with a firearm, arrest them under state law, then refer to federal prosecutors for harsher sentences. Preservation Acts shatter this pipeline by prohibiting state officers from referring cases to federal prosecutors and banning state testimony in federal firearms cases. Missouri's law explicitly states no state employee can make arrests or participate in enforcing federal firearms regulations. The Western District of Missouri demonstrates the immediate impact. Federal firearms prosecutions there fell 44.9% in just 2 years to only 103 cases. Defense attorneys filed motions to dismiss in 67 cases, arguing state police violated Missouri law by cooperating with federal investigations.
And today, the Supreme Court said that's unconstitutional. That puts a limit on the right to have a gun.
The government may not regulate individuals' possessions of weapons for self-defense.
This case could reshape how far states can restrict your right to carry and where.
When things sound really good for gun owners in court, that doesn't mean it's over.
This will get appealed, and this might go back and forth a little bit. But for right now, this is where we're at.
If all 27 states fully implement these restrictions, federal gun prosecutions could plummet from 12,000 annually to under 6,500. The pistol brace rule provides a perfect example of how federal regulations become unenforceable. The ATF's 2023 rule declared pistol braces turned pistols into short-barreled rifles requiring registration. They estimated 10 to 40 million braces existed. By the amnesty deadline, only 255,000 were registered, a compliance rate between 0.64 and 2.55%. The ATF's enforcement strategy depends entirely on state police discovering unregistered braces during routine encounters. They cannot conduct door-to-door compliance checks. Texas alone has an estimated 2.8 million brace owners, only 18,400 registered, a 0.66% compliance rate. If Texas passes their Preservation Act, 89 ATF agents would have to identify and prosecute 2.78 million violations without help from 167,000 state officers. That's 31,236 violations per agent. Mathematically impossible. This Supreme Court precedent extends far beyond guns to fundamentally alter American federalism. The anti-commandeering doctrine now applies across all policy areas with an 8-1 supermajority endorsement. Democratic states are already drafting legislation to resist federal immigration enforcement and environmental deregulation using identical legal reasoning. California announced plans to prohibit cooperation with ICE deportations. New York introduced bills blocking database sharing for immigration enforcement. Republican states are going even further. Texas introduced legislation prohibiting enforcement of federal methane emissions regulations exceeding state standards. Florida's Attorney General declared the state can refuse assistance with offshore drilling restrictions. The federal government has operated since the New Deal, assuming general state cooperation even with policy disagreements. That era just ended. Federal agencies employ approximately 37,000 field agents combined. State and local police number over 700,000. Without state cooperation, federal enforcement becomes mathematically impossible across vast swaths of American territory. The FBI, DEA, ATF, IC, EPA all face the same enforcement crisis. This Supreme Court decision will be remembered not for changing gun laws, but for permanently devolving federal enforcement power to state control. We're witnessing the most significant shift in American federalism since the Civil War, and it's happening right now as 27 states prepare to flex their newly confirmed constitutional muscles. The federal enforcement collapse isn't coming, it's already here. Half of America just gained the constitutional power to nullify federal gun control through simple non-cooperation, and there's nothing Washington can do to stop it. That's it for today, folks. See you in the next video.